Anyone?
Yeah. And I want y'all to feel free to stop at any time and ask questions. This is an interactive, and the only way you're going to learn is to ask. And if you're thinking of a question, you better believe that your client's going to think of the same question, and they are going to ask you. So
I have one.
Uh-huh.
I was in a inspection training today, and he actually brought this up about the contract that he said a lot of agents don't do properly. And that is, I'm trying to think of what number it's at off the top of my head, but it's the regular 1 to 4 residential. And it says where you put in there, seller not to exceed however much money, say that you've talked about giving so much, maybe $6,000 towards closing cost or something like that.
Uh-huh.
Now, before you put that money figure in there, you need to be in contact with the lender to make sure that that's not more than the lending allows, because like FHA, you can put a higher number, but when it comes to conventional, the seller cannot give the buyer anything towards the down payment.
Right.
So so he said some of that money could just go to waste. Like if say it was we put 6,000 down and they agreed on 6,000, but then come to find out because of the loan they got, all that they would by law be able to give would be the 3,000. He said the other 3,000 you've just left on the table. When you could have had the house payment, you could have had the house lowered in price or something different to make up that difference.
But it's good for if you're representing the seller and that stays on the table.
Oh yeah.
3,000 in the
He was talking more for the buyer's agent, but I didn't even ever think about that.
Yeah. Yeah. But I have had that come up to where I've had a closing and some was left on the table and I represented the seller and it was all good. And then I had another closing where I represented, I think, the buyer. And in here, it details every single thing that the money can go towards. And I was looking, there's a paragraph in here. I mean, it's a word. Okay, and other expenses payable by seller right here. I don't know if y'all can see that's a sign. Approve. Oh, you trying to make it bigger, Chad?
That's okay. Go ahead.
Okay, so right here, where'd we go? This little clause, where did we go? Is that I made it bigger and then I lost the clause?
Yeah.
Settlement and other expenses. Okay, right there is where it says allowed by lender.
Yeah.
On B. And then to buyer's expenses as allowed by lender. And where's the other one? Releases of existing liens, including prepayment penalties and recording liens, release of seller's loan, tax certificates, deed, 1/2 escrow fee. Right there, that's it. Okay, and other expenses payable by seller under this contract. So one time I had money left on the table and that was good for my seller. But then the next time, the other agent who used to be in lending or something.
Oh, yeah.
She said, this little verb right here, this little comment makes it to where there's nothing left on the table. Because if the lender won't allow it, then it goes to the title. But it can't go towards down payment, but then it goes to title fees or what other fees. So really, it's just how you interpret the contract, and it's, and it can be interpreted. Is that the right word? Interpreted either way. If you have an agent that fights and says, nope, it's going towards this, this, and this, then it goes towards that, and that. If you have an agent that doesn't know and it's left on the table, then if you're representing the seller, let it be left on the table. In any dispute, because I even called the TAR legal line, about that to try to get it figured out which way it goes. And they said the same thing. It's up to interpretation.
Wow, that's pretty good.
Yeah. Yeah. And a lot of, for the newer agents who really are just coming on and getting your license, all of these forms that you're using is basically to cover yourself or the brokerage, because really it's all in the brokerage's name, if you get sued. Because you're just trying to think of, okay, if I go to court, what's going to hold up in court, what's going to say that I'm doing my job, and really that's what all of these forms are, because TREC doesn't say, well, when you sell a house, you absolutely have to have this. It's just what the brokerage feels is necessary to cover themselves if they get sued. So that's why different brokerages require different things. But that's a good one, Dee Dee, because that one is very ambiguous and can go either way. A lot of these are ambiguous and can go either way.
Yeah, they were explaining a little bit of the differences in the FHA, VA, and the conventional one. And he was talking about the problem is usually boils down to the inspections, because he said the FHA is really a difficult inspection, but he said the VA is even worse than the FHA.
Oh, VA is absolutely.
Yeah, and they said, so why, when you're in a multiple offer situation, a lot of times it'll come down to simply what kind of loan that your client got on whether we get picked and the other person gets picked.
Yeah.
And it's very frustrating, but it's just the way that it is, because those are government loans, and well, government has a little more hoops and whatever to go through.
Yeah. Well, and it's going to take longer in closing. And if you have a VA loan compared to a cash loan, that, okay, there's so much that can go wrong that we probably won't get to closing.
Yeah, exactly. Or we could lose the whole thing.
Yeah. So cash is always good. So yesterday we went over the 1 to 4, and afterwards I was asking Chad, it's like, okay, Chad, what do you think we need to do to kind of make this better? And he's like, have a filled in contract so y'all can see what's filled in. So I pulled up a couple of contracts and this one is one, a small little amount. It was only a $10,000 cash deal for a little bitty lot in Tomball. And if you have a small transaction like this, and you can see this is on the unimproved property contract. This is not the 1 to 4. And we're going over the 1 to 4 tonight, but I pulled up the unimproved. If you have a small transaction like this, don't do 3% where you're only making 3%. I have a minimum. My minimum is $1,000 for each side. What would be 3% of 10,000? Would that be 300? Let's see. That would be
3,000.
Well, 3% of 10,000 is $300.
$300.
That is not worth your time. That is so not worth your time. So I always, if I have a small deal like this, I tell the seller outright, okay, my fee is going to be $2,000. It's going to be $1,000 for the buyer's agent, and it's going to be $1,000 for my brokerage. So because anything less than that, it's not worth your time, and you don't even want to mess with it.
Yeah.
So let's get to the 1 to 4. And guys, y'all would be so happy. I thought, well, let me try to make a PowerPoint. So I thought a PowerPoint might help too in these classes. So we're going to go over the 1 to 4 residential today. And the very first thing is you need to know when to use the 1 to 4 residential resale contract. You use it on resale. You do not use it if it's a new home build. You don't use it if it's unimproved property. You don't use it if it's commercial, and you don't use it if it's farm and ranch. Commercial and farm and ranch are two whole different stories. Let's see if somebody's trying to, I'm at casino. Somebody texted, I said, you're going to be at the class tonight, and they're at the casino. No. So commercial and farm and ranch are a whole different ballgame. Farm and ranch, it conveys like some of the equipment with it and the crops and, you know, you really, there's no limit on the amount of acreage it has to be for a farm and ranch or for a residential, because you can do, it depends on what the land's being used for. You can do a residential contract that has 30, 40, 50 acres. You know, you don't have to use a farm and ranch unless it is more of a farm and ranch. So this is going to be the contract that you use the most. You're going to use the residential resale contract the most, and then you're going to use the unimproved property that we were looking at earlier. This one is going to be used when there's no improvements on the land. You know, there's no residence, it's just strictly an undeveloped piece of property. So that's when you use this one. Okay. So for, I've split it up, and TREC is coming out with the updated residential contract. They're coming out with all the new contracts, but the updated residential contract goes into effect in April 1st. I think mid-February after TREC meets, you can start using the contract voluntarily, but it's going to be mandatory April 1st. So you'll see on this PowerPoint where I will have the old contract and then I'll have the new contract, so y'all can see them both. So right now you're looking at the old contract, and the second section is going to be the legal description. Now, legal descriptions can range from, you know, a couple of lines to half a page. It really depends on how old they are. Like this one right here, this one does not have a lot and block. The legal description was just AO 613 Ward Cyrus Tract 6, 6.52 acres. And a lot of times your undeveloped property will not have an address, you know, so the legal description you can find on the survey, you can find on the MLS. It should have it on the MLS listing, or you can find it on Realist, the tax system. And, you know, I'll show you how to look up all of, I'll show you how to look up each of those systems, you know, at a later time, you know, and show you how to find the legal description. But if you have to, you can, if it's a long one, you can also put see attached, because they have it right here, or as described on attached exhibit. So you would just go to your Word document and put exhibit, you know, 1, attachment 1, and you would cut and paste the legal description and you would submit it with the contract. So improvements. Improvements, they're really basically telling you what is being sold with the house. You know, anything permanently attached or any improvements that you've done is going with the house. So improvements could be like a deck, you know, that's going with the house. And it lines it out, you know, everything that is considered an improvement. Some agents will list like appliances, you know, dryer and not dryer. I've seen where they say the stove stays, you know, well, you don't have to list that. The stove automatically stays, but the refrigerator does not. So, you know, if you see a listing that says refrigerator stays, normally the refrigerator doesn't. So that's a good thing. That's a bonus to your buyer. Accessories are anything that can be moved. So some accessories that are not permanently attached normally stay, you know, like draperies and rods. The rods are permanently attached, the draperies are not, but the drapes stay. Air conditioner, a little window air conditioner unit, that's not permanently attached, but it stays. So the difference between the improvements and accessories are movable and improvements are permanently attached. This C is what is in the current contract that we're using. Now the new contract adds that controls, which includes the seller's transferable rights to the software and applications used to access and control improvements or accessories. That also conveys with the sale. So really, if your house is a smart house and you have an iPad that runs it, or, because I've seen it to where the iPads are in the wall and you control it on the wall, they're saying that that software and that iPad conveys with the house. If you do not want it to convey with the house, you need to put it in the exclusions. And if you don't have any exclusions, you put in A. So, let's say your client has the Ring doorbell and they want to take their Ring doorbell with them. You would exclude it, Ring doorbell. If they have a chandelier that they don't want to leave, it's grandma's chandelier, you need to put that exclusion right here. And the current contract and the new contract basically are the same with the exclusions in how it's listed. But always, if you do have something that is not part of the contract, like let's say you're making an offer on the house and you want the refrigerator. So your client offers to buy the refrigerator for $500. You would put that on a non-realty items addendum and you attach it to the contract, if your client wants it, and you just put, refrigerator, non-realty items addendum, $500, and you attach it with the contract and submit it over. Now, what I have heard is that you want to maybe take a picture of that refrigerator and write down the model number, because, if you just put refrigerator and not the brand or the model number or anything like that, what happens if they have a refrigerator in the garage that's a lot older and they change it out? They take the one that's in the kitchen and put the one that's in the garage there, and they leave you a refrigerator because you didn't note on the non-realty items addendum that it's the Samsung with the, screen access where you can order your groceries on the refrigerator. That's the one you want. Yeah. So that's just a side note. So this is the new contract that's coming in April. So you've got the sales price, that's the same on the new and the old, and it's pretty basic. You're going to put how much, this particular deal was a cash deal, so it's just $450 in the top part of cash, $450 in the bottom. If it was a finance, you would put, they're putting down $20,000 or whatever they work out with the lender, because it's up to the lender what their down payment is, not you. $20,000 third-party finance, they would have a third-party finance addendum attached. And the difference, you will work with amendments and addendums, and just know that addendums are something that is attached to the contract. It goes with the contract as part of it. An amendment is something that changes the contract after it's already been executed. So after you get the inspection back and your client wants to have $5,000 towards concessions towards repairs, you would amend the contract to show that. Okay, now the new 1-4 that is going into effect in April, it has a part, I jumped ship. It has a part about leases. There's a very small blurb in the current 1-4 about leases. It's really not that big at all. And I think it just says, the buyer will, the buyer gets possession of the property at closing or funding or according to the attached lease. And really, I think that's about it. The new 1 to 4, it goes over residential leases. If you have, like, you're buying a property that has a renter in it, fixture leases. That is if you're renting solar panels, or it names it solar panels, propane tanks, water softeners, security systems. There's going to be a separate addendum for that. There's going to be a separate addendum for the residential leases. And then it's got natural resources. Natural resource liens means all existing oil and gas, mineral, water, wind, or other natural resource lease affecting the property to which the seller is party. So let's say, okay, so your client is buying the residence, but they are buying the surface. That doesn't mean they're buying the resources underneath, and it doesn't mean they're buying the air rights above. So they're just buying the surface. If there is a natural resource lease, that means that somebody has the right to come on to that residence that your client is buying and do whatever they have to do to get those resources out of the land. And there's an addendum for that. So just be aware when the new residential 1 to 4 goes into effect in April, it's going to have all of this lease verbiage on it. Earnest money and termination option. So the earnest money, the top part is the new contract. This is what's going to be on the contract in April. The bottom one is our current contract. This is what the earnest money is on the current one. And basically, they really are about the same. The only difference is the new contract in April is combining the option fee with the earnest money. So as of right now, if you are to get a contract on a house or, offer to buy a house, you're going to deliver the earnest money to the title company, and you're going to deliver the option fee to the seller or the seller's agent. And that's going to change in April. So as of April, this says within 3 days, and I think I have it. Let's see if I have another one. Okay. Within 3 days of the contract, buyer must deliver to, and that would be the escrow agent's name. So the escrow agent is going to be at the title company. So Mary Jane as escrow agent at Capital Title, and then their address and the amount. So it would be $1,000 as earnest money and blank as option fee. So here they combine the option fee with the earnest money. And then it says that you can make it payable. You can make it in 2 checks, or you can make it as one. If the last day to deliver the earnest money or option fee or additional earnest money falls on a Saturday, Sunday, or legal holiday, you have till the following day where the title company is open to deliver it. And this is a bonus for us because in the current contract, if the third day to deliver the option fee falls on a Saturday, a Sunday, or a holiday, you still had to deliver it. You had to make sure, or you still have to until April, that the seller got the option check before the end of the third day. And there was no time limit. The option fee could be delivered at midnight. But now it goes with the title company, which is a lot easier. So we're going to go back here. And this says basically the same thing. Normally, if you have a second option, and that was in here as well, it had a second option or a second earnest. Buyer shall deliver additional earnest money of blank to escrow agent within blank days of effective contract. So that's the same thing as this part right here. That's normally like a builder. if a builder is building a house and after they get to a certain point, they want another down payment, we could do a second earnest money check to the title company. I've personally never seen a second earnest money check used here or a fee put in there. I don't know why somebody would require it other than the builders, but they have the new build contracts. So, you know, and a lot of builders use their own contracts. They don't even use the new build contracts. So I'm trying to earnest money. I thought I did I thought I did a PowerPoint that showed the difference between earnest and option. Maybe I didn't. Okay, earnest money. Earnest money is a deposit made to the seller that represents the buyer's good faith to buy the home. It's just really telling the seller, hey, I want your house. I'm going to put down $2,000 so I can tell you I really want your house, but you know, I'm going to put down $2,000 to hold it while I do my due diligence. So that's all it is. Earnest money is the good faith money. Earnest money goes to the escrow officer, which is the title company, and it's deposited into an escrow account. Earnest and escrow are two different things. Oh, that's what I was thinking about. Earnest is the money you give. Escrow is the account. They call it an escrow account that the title company puts the money in. So it's easy to get those two confused when you're first starting out. Does anybody have any questions on earnest or escrow?
No.
Yeah. Earnest money does not have to be 1%. You know, there's no written rule of what your client has to offer. You will get agents that say, you know, 1%, but they can't tell your client what their offer should be. If they take your offer to the seller and the seller says, hey, I want more than $50 as a down payment, they're not too serious, then that agent can come back and say the seller's, you know, rejecting your offer because of this. You know, but a lot of times the agents will put in the agent section, you know, 1% earnest money, and what, like 200 option fee, 10 days or 7 days max, and they can't do that, but they do. Earnest money can be a check, a money order, or a wire, and they all go to the title company, and it has to be delivered within 3 days. Time is of the essence. In the contract, they have time is of the essence a couple of times. They have it in the option part, and they have it in the earnest money. So when they have time is of the essence in the contract, you really kind of need to pay attention to it. This is.
I have a concern.
Mhm.
Yeah, the differences between the honest money and also the down payment. I believe the honest money is there specifically just to ensure the buyer that is probably in need of the house or the property. But there's an option right there because I can give an honest money or I cannot, depending with the agreement between the buyer or the seller.
Right.
But the reason why we have honest money is because in the future, in the case maybe you want to protect yourself from probably getting certain, you know, privileges, and that's why we give the honest money. You know, so I may not give the honest money, but I can proceed with the purchase if we agree between me and the seller or the buyer.
Right. And it's if the buyer, I mean, you can absolutely submit a contract that says $0 as earnest money. I think it should be a nominal amount, but it doesn't say a nominal amount. I know on the option period, I'll show you on the option period. Oops. Okay. So on the option period, it says right up here, for a nominal consideration. So that means you have to have some money in there. I mean, you have to have a minimum of $1. It doesn't say that on the Earnest. On the new contract that's coming into effect in April, it specifically states in here, let's see, if buyer gives notice, if buyer fails to deliver the earnest money, nope, that's not it. If no dollar amount is stated as the option fee, or if buyer fails to deliver it. So it specifically states that you have to have a dollar amount in the option on the new contract, but it doesn't say that on the Earnest anywhere. You know, so you could absolutely put 0, but I think for a court of law, it needs to be at least a minimum of 1. But that doesn't mean that the seller has to accept it. He could always reject it and say, no, I'm not going to take my house off the market. If you're not, you got to have a little skin in the game. You know, you put up some money and show me you're really interested, and then maybe I'll take my house off the market. Is that kind of what you were saying?
Yes, because I believe the honest money protects probably a buyer from collateral damage in the future, in the event that maybe you decide to change your mind. Because if you give the honest money, that protects you. And if you don't give the honest money, the seller can sue you or enforce you to actually purchase the property based on the previous agreement.
I don't know if it really protects the buyer. What would it protect the buyer from?
Let's say you actually proceed with the transactions and you decide to change your mind due to certain maybe contingency.
Yeah.
Now, if you did not give the honest money, you know, based on the time of essence, the seller has the power to actually proceed with the court hearings, preventing you or forcing you from buying the property, or can even impose certain, collateral damage on the property, because probably I've already taken out my property off the market. You know, presumably somebody else could have actually bought the house, but because you actually agree on the content and later on you change your mind that you're not going to go ahead with the transaction. So I as a seller, I have the power to actually to take it to court and enforce you to purchase the property. I believe, based on what I read or understood, that's the key reason why we have that honest money, and it has a time of essence. And I'm not sure if I'm right, but I would like to hear more from anyone.
It basically, kind of assures the seller that if you do change your mind, and it's right here in paragraph 15, it says seller may terminate this contract or exercise seller's remedies under paragraph 15. So if the buyer or the seller, either one of them can get out of the contract normally at any time. You know, the only remedies are to sue for specific performance. And basically, if you're a seller and your buyer loses his job and gets out of the contract, and, you know, are you really going to, no judge is going to enforce the buyer to buy that house, you know, because of the circumstances, you know, so the seller's really not going to sue for specific performance. I've yet to see anybody sue before specific performance. But who gets the earnest money is up to debate. You can interpret the contract, and if the buyer backs out and the seller gets to keep the earnest money, the buyer can refuse to release the earnest money, you know. And I just had this come up with an agent today. You know, if the buyer refuses to release the earnest money, they won't sign off, because when you terminate a contract, you send over the termination and you send over the release of earnest money. That title stays open, and the seller is kind of stuck between a rock and a hard place, to where they really can't open another title until this one's cleared. So, you know, even if the seller legitimately and legally is entitled to the earnest money, we can't tell them, hey, you're going to get that earnest money no matter what, because the buyer can just be a butt, and the seller's only recourse if he wants to sell his property is to sign the release and then sue the buyer, you know. So it's all legalese, and if you go to a court, it depends on how the courts interpret it, you know, and a court can go either way.
So let's assume that I pretend to purchase a property, and I fail to deliver honest money, and I've agreed based on the 3 days. Then after a certain period of time, that the contract is based probably 15 days. That means the transaction has to be completed. But in the future, something happened. I failed to meet that due date. Now I request to amend the date so that I can get a fund. Now, if a buyer did not give the honest money, it gives a room for a seller to actually reject the extensions or the dates. I believe that's the power of the honest money, because if you do not give honest money, a seller can actually object or reject any extensions of the dates. You know, let's say, okay, we're gonna close the closing date to the 20th, and the buyer is not ready to close on the 20th, and they're requesting to amend, the date. And if a seller did not give the honest money, if the buyer did not give honest money, a buyer can reject to extend the date and force that the transaction has to go through on the date that was specified in the contract.
Well, it basically addresses what you're asking. So if buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15, or both, by providing notice to buyer before buyer delivers the earnest money. So let's see what paragraph 15 says. Let's find the contract. And paragraph 15 is basically saying you have right to specific performance. Let's see. So default. If buyer fails to comply with this contract, buyer will be in default, and seller may enforce specific performance, seek such other relief as may be provided by law, or both, or terminate the contract and receive the earnest money as liquidated damages, thereby releasing both parties from this contract. If seller fails to comply with this contract, seller may be in default, and buyer may enforce specific performance, seek such other relief as may be provided by law, or both, or terminate this contract and receive the earnest money, thereby releasing both parties of this contract. I can tell you right now, if you have a contract and it goes to the title company, and now are you asking like if there's a zero in the earnest money amount, or if the seller just doesn't deliver it?
If the buyer didn't deliver on time,
or the buyer doesn't deliver. If you have a contract and the buyer doesn't deliver at all, period, the earnest money, nothing's going to be done. That contract's not valid because there was no consideration given. You know, for a contract to be valid, you have to have meeting of the minds. Both people have to agree. Consideration have to be given. A title company is not going to open title without some sort of payment, you know. And if they deliver it on the 4th or 5th or 6th day, you know, the title company will note when they get the earnest money. But if you get to the closing date is September 5th, and your buyer didn't deliver the earnest money until 10 days after the contract. It doesn't matter when he delivered that earnest money. If you're closing September 5th, you don't have to extend, and you can keep the earnest money if the seller can. If, you know, like if the buyer can't close because they can't get third-party financing. It all depends on the dates and how the dates fall, if the seller can keep the earnest money. But the seller does not have to extend whether the earnest money was dropped off within 3 days or outside of the 3 days. The seller absolutely doesn't have to extend the closing, but him getting to keep the earnest money is up to interpretation of the circumstances. Did that explain it, Chad, Dee Dee? Did that explain it right?
Yeah, it does, because when we think of honest money and option money, that's two different things. Because honest money can be even $100, $1. But the problem is the actually auction money, the money that you pay. Because when I seek for collateral damage, I'm not going to ask for honest money in order to settle the situation. The issue there, somebody might be looking into, it'd be like the option money. That could be a little bit more than honest money. That's where I'm actually concerning about when it comes to failure.
So the option fee gives your buyer, and when you want to always recommend your buyer to have an option or to have the option fee or the option time. And the option fee gives your buyer an undisclosed amount of time to, not undisclosed, an undisputed amount of time to cancel the contract for any reason. So if you've got a 10-day option, your buyer can cancel the contract for any reason and supposedly get his earnest money back. But still, even though he's supposed to get his earnest money back, if you get a jerk of a seller that says, no, I'm mad that you are canceling the contract, I'm not going to sign that release. We can't force that seller to sign the release of earnest money. We can't force the buyer to sign the release of earnest money. And it would be tied up till kingdom come or until somebody goes to mediation or they work it out. But you can't force either, whether that party is in the right or the wrong, you can't force them to sign. And the new contract, I think, says something about if you, let's see, if you don't sign and you're in the wrong and y'all go to court, you're going to be in a world of pain. Let's see where that is. Possession. Maybe it's still 15. And other such relief. Terminate. No, it was a part where they said they could add extra stuff onto it. I don't see it now. But there is a part in here that says, the party, federal representation, damages. Any party who wrongfully fails, that's it. Any party who wrongfully fails or refuses to sign a release acceptable to the escrow agent within 7 days of receipt of the request will be liable to the other party for damages, the earnest money, and reasonable attorney fees, and all costs of the suit. So that's the part to where if your party is in the wrong and the seller or buyer, either one, is deserves the earnest money. So let's say the seller deserves the earnest money and the buyer's refusing to sign, then this part right here is saying that the buyer is going to be like in a world of trouble. he's going to get hit for damages. He's going to get hit for the earnest money. He's going to get hit for the reasonable attorney fees and all other costs. But, you know, who's really going to sue? You know, you're going to spend, let's say you're going to sue, earnest money's $2,000 and you're the seller and that's the buyer owes you $2,000 because he's refusing to release it to you and you're in the right. So you're going to go pay $10,000 to an attorney to go get mediation and sue them to get the earnest money back? I mean, that's the fault of our legal system, is where not unless you just want to sue for the principle of it, because you're going to teach that buyer, hey, you know, you screwed me, you're wrong, you're in the wrong, and I'm going to pay $10,000 to make you eat that too. But then, you know, then the judge could side with the buyer and then you lose all of it, you know. And getting a judge, you never know which way they're going to go. They don't have to rule by the letter of the law. They can say whatever they want. They could be friends with that buyer and rule in their favor. You know, it's really a catch-22, I think. Does that answer your questions? Does that make sense?
Yes, thank you.
So, and there was something else I wanted to point out. So with the earnest money, we're going to go back to the earnest money. Property condition. Okay, so you have so many days on this objection. This is in the title company. We're going to the title company. So right after the title policy, you have the commitment that talks about the title commitment, and then the survey, and then you have your objection period. This gives you a certain number of days to object to something you see in the title policy or on the survey. And a lot of agents will put right here, okay, buyer, we're just going to read it. Buyer may object in writing to defects, exceptions, encumbrances to title disclosed on the survey, other than items in 6A1 through 7 above, disclosed in the title commitment, other than items 6A1 through 9, or which prohibit the following use or activity. And a lot of agents will put residential right here. And then you can put a number of days. But really, this says buyer must object the earlier of closing date or blank. So it's kind of better not to put a date here, because if you put a date, you're giving yourself, let's say you put 5 days, you're giving yourself 5 days to object to the survey or the title commitment once you get it. But if you leave that blank, it says buyer must object the earlier of the closing date. So you're giving yourself to closing to kind of object. So it's earlier to kind of leave that blank. And on this, agents will put residential. And today we had it come up to where the person is buying a piece of property and they wanted to use it for a mobile home. Well, they found out that they can't have a mobile home on this piece of property. So if residential for use of mobile home was put here, that would give that person a reason to get out and get the earnest money back. Now, like we said, if they get the earnest money back, it's all up to fate, you know, because one party could refuse to sign even though they're supposed to sign. So right here, you really want to talk to your client and see what they're using the home or what they're going to use the property for. You know, if they're buying a house and they want to put, last night I used an Olympic-sized swimming pool as the example. You would put residential with Olympic-sized pool. If they want to use this property to raise pigs, residential to raise pigs, you know, and I can guarantee you, you're really not going to find a property that will let you raise pigs. That's going to be hard to come by. So they would have a chance to get out. So talk to your client and just don't just put residential here. You'll see residential or commercial, you'll see single family residence. You want to kind of expand on what they're going to use it for, you know. So it just kind of helps your client to have an out to get the earnest money back. Now, once you see something on the survey or the title commitment, you have either the earlier of the closing date or this number of days to object. And so I wanted to, first I wanted to show y'all a survey, because maybe some of y'all haven't seen a survey. So I wanted to show you a survey, and then I wanted to show you some title policies and kind of what to look for. So this is a survey that was actually trying to blow it up. Let's see if we can blow it up. Oop, that's horrible. This was a survey that was actually one of my clients. It was, okay, so y'all, this is the legal description. This is the stamp. Now you will have surveys rejected. So title companies or lenders can reject it. If it doesn't have the stamp, they'll reject it. I've had it rejected because it doesn't have this north and south arrow on there. You know, legal description's old, you know, they'll reject it. But I want you to look at this survey and tell me if you see anything that kind of jumps out at you. And the surveys plot the build lines, the easements. You should have everything on this survey. Does anything jump out at anybody on this survey? This was a new build, and this was actually, gosh, when was, I think the date's on here. It was the beginning of this year when this was done. I'm afraid to move this around. Oh, there we go. January. Yeah, this was January 2020, beginning of last year. I'm sorry. Okay, look. Yeah, this is a builder. A builder did this. Look over here. What does this say? This says build line. It's a 20-foot build line. Where is that house? This house is over the build line. And a builder did that. He has to be, what, 6.85 feet into the build line to where he can't go. So how do you think that was at closing? Do you think we closed on time? So when you get the survey, you know, you want to look this stuff over, and what you see in this survey will be reflected or should be reflected. So, you know, on the title commitment. So here's the survey, and I actually pulled up the title commitment that goes with this survey. So that one is
do the survey.
They're not listening. The right one.
There's no point.
It's 6 foot over the build line.
It's a funny drawing though.
Okay, that's okay. So this is the title commitment that goes with that survey. And when you get the title commitment, you want to make sure the price is right. This should be your contract price. You want to, why is it changing to a pin? Okay, so you want to make sure the price is right. That's the contract price. You want to make sure the name is right. Yeah, that's on the contract, because the commitment has to be in the name. It gives you the amount of the title policy or the loan amount. This is the legal description. So, you know, you want to make sure the legal description's right. And then it gives you all sorts of other exceptions from the coverage. this is where right here, it tells you this 7-foot utility easement, you should see that on the survey. All the easements and all of the 5-foot building setback line from any side, you know, you should see that on the survey. So see, there's the 5-foot, there's the 7-foot utility easement, you know, it gives the build lines. So you should see all of that on the title policy. And then you get down to, and we'll go through a title policy in depth at another time, but this is just quick so y'all can see what's on a title policy. The title company is saying, hey, the survey shows the house is built over the build line. You know, we require you get that taken care of. So what would happen is you have to go to the HOA and see if you can get a variance and see if they would approve, you know, your house being, you know, built over the build line, which this HOA was particularly mad at this builder, and they fined him very heavily. And but you'll see all sorts of things in the title policy that has to be cured, is what they call it. Has to be cured, taken care of before you can close, or the title company will not issue a title policy. And this, you know, outlines all the different things that has to be cured. So in this one, they had to cure that. They're also requiring this builder to show affidavits saying that he paid all the contractors, and then they're requiring the builder to show that he's in good standing with the city. You know, so that's what happened on this title policy. On this one, this is for that $10,000 piece of land, that contract that I pulled up earlier. You know, and there it is. It's got the price and it has the names of the buyers. You need to make sure the names are the same. And then it has the legal description. And this one was like an estate sale. You know, a company was selling it, and the title company required all sorts of things. They required the articles of incorporation. They required, you know, documents that the company's in good standing. They required the partnership agreement, evidence that it was validly formed. You know, the original owner passed away, or the person selling it, his father passed away, and so they required like the probated will and the death certificate. And then, you know, this one took so long to close because the will wasn't probated. They had so many heirs, you know, had to get heirship affidavits on each one. So, you know, you can save a lot of time, you know, at the beginning of your contract. If you know it's a probate and you know the names in an estate, or you know it's a corporation, the title company is going to ask for all this. Just have your client start getting it together right at the very beginning. You know, if it's they're going to ask for the articles of incorporation. They're going to ask for the documents, the company documents. If it's a will, they're going to ask for the probated will. They're going to ask for the death certificate. You know, so just make sure that you prepare your client, you know, hey, if the will's not probated and you have 3 siblings, you're going to have to get heirship affidavits. All your siblings are going to have to fill out an heirship affidavit. You'll have to get 2 witnesses that knew that your parents way back when they had kids, to say, yeah, these are all their kids. We knew them, and they'll have to sign. It's just a big hassle. So, but I thought that survey was just the funniest thing. And I warned my client. I told him, don't buy this house. I tried and tried and tried to talk him out of it. And I wanted him to buy another one. And he asked me, he said, Mindy, why don't you want me to buy this house? And I said, well, it's not, or why do you want me to buy this other house? And I said, it's not that I want you to buy that house. I want you to buy any house other than this house. You know, any house, just buy any house other than this house. He went on and bought this house. And then we find out that it's over the build line. And then after he closed, you know, like 2 weeks after, a week or 2 after, there was an underground pipe leak in that house, new build, a new construction, you know, 2020, built in 2020, where they had to come in and rip up the slab and go in and fix the pipes. And I didn't say I told you so to him, but I should have. But yeah, so don't be afraid to talk to your clients and give them your opinion. You know, they want your opinion. You're the expert. So be the expert, you know. And I told him, look, I don't know this builder, but I know that just from the overall of what we've gone through with him today, that, you know, if all of this is wrong, I don't know what's going to happen, you know, in the long run. It's just a lot of unforeseen stuff. And sure enough, you know, get the survey and it's over the build line and then the pipes and, you know, so, but I do have good builders. If y'all do have clients building the houses, I can recommend good builders. So,
Mindy, quick question for you.
mhm.
What exactly did you see that was like a red flag that made you not recommend the house? What did you see with the builder that made you kind of have doubts?
There was a lot of little bitty things, you know, when they cut a lot of corners, and you can tell they're cutting a lot of corners. If you can tell it, you know, just off the stuff that you see, then there's going to be corners cut on this unforeseen stuff, you know, like the stuff underneath. In this one, I think the main thing was there was a huge drainage issue in the back because of the way that they graded it. And then some other things to where I'm like, look, you know, his name's Monty. Monty, you know we've got these problems right here. Let's just kind of go somewhere else, because if we know we have these problems, there's going to be a lot of problems that we don't see, you know. And sure enough, that's what happened. But it was kind of my fault too. Not really my fault, but he was using a builder that I never heard of. And I didn't research the builder to see how many houses he had built before we put in the contract. We found it out after we put in the contract, and we started seeing some stuff go wrong, that this was only that builder's second house. So that's kind of on me. If I would have kind of researched the builder before we put in the contract, I mean, my client would have probably still put in the contract on it because he liked the location and he loved the aesthetics of the house, you know. But still, I could have forewarned him, like, hey, I don't know this builder. This is only a second house to build. And so make sure, if you are working with a builder you're not familiar with, ask them, you know, how many houses have you built? Because builders, there's no regulations in the state of Texas on building. Anybody can make up a business card and call themselves a builder. Absolutely anybody. So, are there any other questions on like a survey or title policy or anything like that? Can anybody tell me what a title policy is? Because your client will ask you, they'll say, what's a title policy? Why do I need this? Any guesses?
Well, I believe it's like an insurance to the buyer, that in case something comes up later on the title, then they're covered.
Yeah, very good. That's exactly what it is. It's just an insurance policy covering the title, you know, and the title company is saying that, hey, yeah, this title's free and clear, and you're good to buy it. And so that's exactly what it is. There is something else I wanted to point out on back to the earnest money and the objection of what you see on the title commitment. If you see something on the title commitment, and the title commitment is where you should get like the H&O. I think it's outlined in there, the HOA stuff, but not as detailed as the regular HOA stuff. But if there's I'm thinking like if you can't have pigs I'm gonna have to look at that title policy. If it says that, pigs, horses, all that stuff is in there, I'm gonna have to look if you can have it there or you can't have it there. That's outlined in the HOA documents, but I think it might be in some title policies as well. But so let's say that your buyer gets that, he gets the survey back, and right here it says, hey, once he gets the survey or title policy, he can object. It gives the buyer so many days, it's called a cure period, so many days to cure whatever's wrong on that or to fix it. And if the buyer doesn't fix it in the allotted amount of time, then the seller or whoever can terminate and ask for the earnest money. So if a party terminates and demands the earnest money from the title company and the other party doesn't object within 15 days, the party that's demanding the earnest money will get it. But if the other party objects, then that's kind of when you're in the stalemate. So just remember that if they demand the earnest money from the title company, hey, we terminated, we want the earnest money. They have a certain let's see, paragraph 18C. Okay, is that where it says it? Let's see what 18C says. Yeah, that's part of the demand, that they have 15 days to object. So upon termination of this contract, either party or escrow agent may send a release of earnest money to each party, and the parties shall execute the counterparts of the release and deliver the same to the escrow agent. If either party fails to execute the release, either party may make a written demand to the escrow agent for the earnest money. If only one person makes a written demand for the earnest money, escrow agent shall promptly provide a copy of the demand to the other party. If escrow agent does not receive a written objection to the demand from the other party within 15 days, escrow agent may disperse the earnest money to the party making the demand, reduced by the amount of unpaid expenses incurred on behalf of the party receiving the earnest money, and escrow agent may pay the same to the creditors. So, what incurred expenses would normally be the survey. The title companies normally order the survey, and most of the time it's paid at closing from the title company. Sometimes you can write a check, you pay for it separately. Sometimes it's in the closing statement at closing. It just kind of depends on the lender, the title company, and who you're working with. But that would be the fees that the title company takes out of the earnest money before they release the check. So that's something good to know, that if your party, if you're representing the buyer and the seller's refusing to sign the release of earnest money, and you've demanded it from the title company and they're not releasing, if they don't object or the seller's agent doesn't object before, within the 15 days, then the title company will release it. If they do object, that's when you're kind of at a stalemate, and the clients in this contract, the clients are agreeing to go to mediation before they sue, So another thing is, anything that you say to a client, if you verbally say, hey, you need to get a title policy, they're refusing to get a title policy, or they're refusing to get a survey or an inspection, you need to have that in writing. There's forms for that, a form where the seller signs or the buyer signs saying, hey, we're bypassing the inspection, we don't want it. There's a form for that. It needs to be in writing that you said, hey, you need a survey, or hey, you need an inspection. And if they refuse it, just fill out the form, and that way you're covering yourself, because really, if you if you get sued, if they take you to TREC, if they file a complaint with you for TREC, you know, you're covered. You said, hey, you know, I told him not to buy that house. You know, I told him to get an inspection and he refused. Here's my documents. You know, they're not going to go by your word. It's got to be in writing. So make sure whatever you verbally tell your client, there's a form, TREC has a form for everything, or you back it up in a text message or an email or something written. Oh, there was something else I wanted to point out, but it totally slipped my mind. Oh, survey. Now I know what it is. When you order the survey, now tell me if I've already covered this. I'm getting last night's Zoom mixed up with today's Zoom. When you order the survey, make the title company will order the survey. Make sure that the loan is going to go through. Make sure that your third-party financing is good, that you have the any sort of amendments for that something that came up on the inspection. If the seller's got to fix anything, you want to get those amendments in writing and agreed upon before you order the survey, because you don't want to order the survey right at the very front of the contract and then it falls through. You know, then you're kind of stuck and it's like, who pays for that survey? You know, it's, well, if the seller's refusing to pay and the buyer's refusing to pay, it's going to come out of the earnest money. And then whoever gets the earnest money is going to be short what the survey is. So you want to watch your dates. And the title company normally will ask you, all right, you want us to do the survey now? You know, you want us to order it? And so just be mindful of that. I'm trying to think, did we finish the PowerPoint? So for option period. So for a nominal fee, I think we kind of talked about that briefly. Nominal fee in the option period could be $1, but just them having the word nominal means that there needs to be a dollar amount in there. So I wouldn't put 0 in the option. And like I said earlier, on the new contract that's coming out in April, it says that there has to be a dollar amount. If there's no dollar amount, then it's your client's not doing an option. So for a nominal fee, seller gives the buyer the unrestricted right to terminate the contract by giving notice of the termination to the seller within the certain number of days after the effective date of the contract. The effective date of the contract is going to be the date it was executed, and a contract is not executed until the other party is notified. So if you sign tonight and you don't tell the other agent, you don't shoot them a picture, you don't shoot them a text, you don't, you know, send them the contract, and you don't tell them, hey, we have an executed contract, and tomorrow morning they call and say, oh, we're canceling that contract, and you're like, well, no, it's executed. You didn't deliver it. You didn't deliver it to the agent. So it's not considered executed until the other party is notified. Option period is normally 7 to 10 days, and the normal option fee is 100 to 150. You know, you really, if you have a commercial contract, you're gonna see option periods that go for 60, 90 days. You're gonna see it's gonna be a lot longer, because commercial contracts, they are getting all sorts of government permits and licensing to make sure they can do what they want to do there, and that takes longer. Our option period is 7 to 10 days. You want to have your client get the inspector, you know, right at the very beginning. As soon as the contract's executed, the first day, you know, have them get the inspection on order if they're going to do the inspection. If you recommend an inspector, you need to recommend 3. You know, don't just recommend 1, because you can get sued for that. Everything you can get sued for that. You know, it's just better to say, hey, you know, if you're standing before the judge, hey, I recommended 3 inspectors, you know, to my client. I said, these 3 are all good inspectors. Please choose whichever one you feel most comfortable with, which one has the price that you want. And that way, if you go to court, you know, the client can't say, well, they're in cahoots with the inspector. The inspector left this foundation problem out because they're in cahoots with the realtor, and so they're working together. You want to bypass all that. You want to err on the side of caution. If you ever recommend, any kind of contractors, builders, inspectors, even some, you might have to order a survey every once in a while. You want to do it in threes. And so if somebody's asking for a 15-day option on a residential contract, you need to ask them why. Why are you wanting longer than 10 days? Or if they're asking 20 days, 30 days, I wouldn't go for that. Have the buyer order the inspection as soon as possible. All repairs are negotiated during the option period. And the amendment to the repairs should be signed and agreed upon before 5 p.m. on the last day of the option period. If you can't come to an agreement on the amendment for the repairs, you need to make sure you explain everything to your client, but you want to make sure, if you're representing the buyer, that buyer has every right to get the earnest money back. So if you can't come to an agreement on the repairs by 5 p.m. on the last day of the option, you need to send over a termination letter. Doesn't mean you can't negotiate, you can't negotiate after you've sent over that termination, because you still can, but you're covering your client. You're covering them, saying, look, they've just changed their mind, they want out of the contract, they're sending over the termination. That way they get their earnest back. But like the house, the one with the survey, I think I sent over a termination twice, but we still negotiated after this termination. It was just an ongoing nightmare. Let's see. And I think that is the last of option. The option fee is non-refundable in the new contract. In the current 1 to 4, the option fee is negotiable if it's applied to the contract price or if it's not. In the in the new contract, it's automatically applied to the purchase price. So in the current contract, it gives you the option. Let's see if we have it right here. It says the option fee will or will not be credited to the sales price. This is the current one. In the new one, it's automatically credited to the sales price. So you don't have the choice on that. Okay, new 1 to 4 also states if no dollar amount is stated as the option fee, or if the buyer fails to deliver the option fee with the time required, buyers shall not have the unrestricted right. So if you don't deliver the option fee by that 3rd day, then your buyer waives the option or the right to have the unrestricted right to terminate the contract. You must deliver the option fee, not the buyer. It's not the buyer's job. It's your job. You're the agent. They're paying you. Go get the option check and deliver it. But that's all going to change in April because it goes to the title company. So it's going to make it a lot better. But as of now, if you do a contract before April, you get the option fee. You put it in the seller's hand, or you put it in the seller's agent's hand. Option fee is made out to the seller. The earnest money is made out to the title company. Let's see where. And I think that is the last of my PowerPoint. The rest of this, prorations. Okay, so settlement and other expenses. This really kind of tells you who's paying for what. This is where if the buyer's asking for, the seller to help, and I think we covered this earlier, it's going to go there. That was right at the very beginning. This tells you what is the buyer's expenses and what is the seller's expenses. The escrow fee is going to be split between both of them. The Title policy is different. The cost of the title policy is not the same thing as title fees. Title policy is for the insurance policy. The title fees is what the title company charges. Title companies charge different fees. Some title companies, their fees might come up to $300. Some title companies, their fees might come up to $500. So it just depends on the title company. The taxes, prorations, this is saying that the title company will prorate the taxes, and it's a guesstimate because like they'll use last year's tax rate to get what the taxes are for the closing, and the up to the day of close, the seller covers those taxes. The day of close after, the buyer covers those taxes. And so if the seller had already paid the taxes for 2020, you'll see a credit on the seller side because they already paid, like they sold the house August 1st, but they paid August through December's taxes. So the title company is going to credit back the seller the taxes from August to December, from August 1st to December when the seller owns the house. It can happen, and it has happened to me, like on a personal thing, a personal purchase. So they use the last year's fees, but in the contract it says that, hey, we're using last year's fees. The fees might be different this year, and you agree to, come back and with the other party and pay the difference, whoever owes the difference. And a lot of times it's not a lot of money, but I purchased I sold a piece of property. It was a private, my property, and the buyer actually came back and said, hey, the taxes came in and you owe me $80 because it was like less or something like that, but I had to write them a check for $80. So that's the only time I've ever seen that happen, and it was on mine. Casualty loss. If the property burns down, well, that's not a good example. So I had an undeveloped piece of property that had a fence. We're getting ready to close, and I think it was like maybe a week before closing, and a drunk driver comes in, and I don't know if they were drunk. They might not have been, but somebody wrecked into the fence. And, I get a call from the buyer's agent saying, hey, have you seen the property? The fence has been wrecked. Somebody wrecked into it. So this is casualty and loss is saying, hey, whatever condition the property's in, that when we put that contract, it's going to be in that same condition when we get it. So my seller had to pay for the fence repair, and that's what they paid for, the fence repair, and we went on to closing. Default. This is basically it's going to be the same for the buyer or seller. Whoever's in default, you each have the right to sue for specific performance. I've never known anybody to sue for specific performance. I've never known anybody say, hey, you have to buy my house. You put this contract on it, you absolutely have to buy it, so I'm taking you to court. I've never known that. But that's what that's saying. They each have the same remedies available to them. Mediation, you're going to mediate before you sue them. They just want you to try to solve it outside of court at first. And then the attorney fees, whoever is found to be in default is going to be the one who has to pay the attorney fees. Escrow agents are like an independent third party. They're not a contract. They're not a party to this contract. So, that's basically what that's saying is, escrow, the agent is a independent third party that's really not a party to the contract. All expenses will be paid from the escrow account by the escrow agent before somebody gets the money back. Demand, I think we went over that. You can demand the earnest money if they don't respond or object within a certain number of days. Then the title company will release it. 21, I pointed this out last night, and So escrow agents notices will be effective when sent in compliance with paragraph 21. Notice of objection to demand will be deemed effective upon receipt by escrow agent. Paragraph 21. This is where you put in the buyers and sellers information. A lot of time agents will leave it blank. Don't leave it blank. You want the notifications to go directly to your client. You don't want to be on the hook, you know, for notifying your client. And the example I used was, I like going through the TREC cases and seeing, you know, what cases are out there and what's the outcome. And I read one to where this lady was doing her final walkthrough, buying a house, and you do the walkthrough. During the walkthrough, she noticed that, hey, the foundation's kind of funky. I mean, wouldn't you notice that in the inspection or some other time? Why wait for the walkthrough? But during the final walkthrough, she noticed the foundation's funky. So they extended the closing. They got a foundation repair company to come out. The foundation repair company came out on, let's just say Monday, and the closing was set for, they extended it to the following day on Tuesday. Tuesday at 9 a.m. At on Monday, the foundation company comes out, says, yeah, it's going to be $8,000 to fix this foundation. Buyer says, okay, you know, I'll do that. Well, and then they go along their way. At 4:40 on Monday, that foundation company emailed the buyer's agent and said, hey, I was wrong. It's not going to be 8,000. It's going to be 12,000 or whatever he bumped it up to. At 4:40, the agent didn't check their email. They didn't check their email for the rest of the night. They didn't check their email that morning, and the buyer went to closing and closed. So after closing, the agent forwards the email to the buyer. The buyer said, hey, you know, I didn't get that email. I wouldn't have closed. And the buyer filed a complaint with TREC, you know. So the agent should have never been the party receiving that. That email should have went directly to the buyer. So you want to make sure you put the buyer's information if you're representing the buyer, the seller's information if you're representing the seller. You want to take yourself out of it. You don't want to open yourself up to liability, which is what that agent did by having the foundation person email them. So, but TREC did rule for that agent, saying that, you know, 4:40 to 5, it wasn't unreasonable that they didn't check their email, but still, you know, you have to go through the TREC process, which I hear is a nightmare, and nobody wants to go through that. So, you know, make sure that if you're working, you don't schedule contractors for your clients. You don't deal with the contractors for your clients. That gets into property management, and you don't do property management. We don't cover property management on our insurance, our E&O insurance. So no property management's allowed. So you just, you can recommend contractors, but you don't pay for them. You don't, you know, be the go-between. You don't be the go-between for the financial side of it. You know, you let them, you can direct them to a loan officer or loan officers. You recommend 3, but you let them handle it all. You can help them, give them advice, always tell them that you're not an attorney, but you know, you can always kind of help them, but let them deal with the loan aspects and the contractors and all that themselves. So federal tax requirements. If you're a foreign person, or if your client is a foreign person, there might be extra taxes for that. So that's just what this is saying. It's notifying that there might be extra taxes. These are all the amendments that you're attaching to the document. If it's a third-party financing, if your client's got a loan, you're going to attach that. You're going to check it. If it's an HOA, you're going to check that. If there's leases, there's just all sorts of amendments that can go along with your contract. And when you're filling out your contracts, call me and call Chad, or, you know, call one of us, and we will tell you what amendments need to, need to be with it, or if you should be filling out a wetlands because it might be in a wetland. And I think all undeveloped properties should have a wetland notification filled out. I think I'm going to start requiring that. I've never done a wetlands before until one of my recent clients, purchased a property that has wetlands on it. And last night in the Zoom, we looked up my subdivision on the wetland map, and I'm like 2 streets over from like this huge wetland. So, the subdivision was built on a wetland. So I think I might start requiring that on all undeveloped property. It's just best to cover yourself. And really, all of these addendums or notifications it's just info that you're giving the buyer, so you're covered if you got to go to court. That's all it is you got to be covered if you go to court, saying, yes, I did tell them about it. Here's the notification. Option fee, I think we covered in detail, and the attorney. You can always tell them, consult an attorney. If you have an attorney, consult an attorney. This is where the seller's agent will put the final acceptance date, and that will be the effective date. Normally, the buyer fills out the contract, sends it to the seller. Seller's agent gets the seller to sign, and they execute it, put the executed date right here. Now, in the new 1-4, they've added team name, and I wanted to point out to those that wasn't on the call last night, they also added this to the contract for us to get paid. Pursuant to a previous separate agreement, such as a MLS offer of compensation or other agreement between broker, listing broker has agreed to pay other broker a blank, and that's where the fee goes in. It's 3% right there. But what this is saying, the new 1-4, it's saying that, hey, the MLS really states what you're getting paid. So it's probably a good practice to, when you submit the contract over, screenshot the MLS listing or download that listing so you have it, because it'll say if you're getting 2% or 3%, and you don't want to submit the contract, have it say 3%, and then look back on it the next day and you see it was changed to 2. And you can't prove that, hey, it was 3 when I submitted the contract, but now it says 2. And this is saying, hey, we're going by the MLS. The MLS states what your compensation is going to be, not what's written here. So it's probably a good practice to print the MLS listing that says you're getting paid 3%, and keep it for your records. And then the last page, this is when the option fees receipted in, the earnest money's receipted in, and the contract's receipted in. And now either the agent or the seller can receipt in the option fee. On the new contract, it's all the escrow agent, because they're taking care of it all. So that is basically the new 1-4 along with the current 1-4. Does anybody have any questions? Is there any other part you want me to go over? I know we kind of skipped over some of these lender repairs and all of that, but does anybody have any questions?
I wanted to confirm something. I'm not sure if you went over it or not. It's regarding the option fee. In the current contract, the buyer has to deliver option fee directly to the seller. And then in the new one, now it has to go to the escrow agent. Is that correct?
Yes.
Okay, that's what I wanted.
Yeah, and the escrow agent is considered is the title company. But so until April 1st is when the new 1-4s go into play. You deliver it directly to the buyer or to the seller or seller's agent, and have them receipt in the option fee. After April 1st, you take it to the title company. And title companies, I'm not sure if we've covered it, but they'll take a check, wire, or a money order. But they're also, some title companies are getting on, I forget the name of it, but where you can take a picture of your check and it delivers it directly to the escrow agent. So you don't even have to leave your house. It's just you kind of like you're depositing into your account, your mobile banking. Some title companies are using that mobile app, and it's a company to where you take a picture of the earnest and is directly deposited into the account that way.
Thank you.
You're so welcome. So any more questions? Thank you guys so much for joining on. I appreciate it. And if you have any questions, if you think of anything after the fact, after we end the class, just shoot me an email, or give me a call. I'm always available to answer any questions you have. I would rather you ask me and you know exactly and you understand fully what's going on rather than your client ask you and you don't know what to tell them. So just reach out to me if you have any questions. Thank you guys. I appreciate it. Oh, I think somebody has one question. Let's see. Oh, you're so welcome. Thanks, guys. Bye.